Welcome everybody to the September meeting of the California Law Revision Commission. My name is Victor King from Los Angeles, California. This meeting is being broadcast by Zoom. It is being recorded, will be available on YouTube later. And as we've said at prior meetings, there will be opportunities throughout the meeting for audience participation. You should familiarize yourself with the raise hand function on the Zoom program, or you could just sort of gesture. Well, actually, you can't gesture. I guess you just have to use the raise hand function. If you're calling in, we'll patch you in. Even if you're not on Zoom, we'll have you telephonically. Let us begin, since I understand we can't see everybody on the video feed. Let's introduce ourselves. Going in alphabetical order, Diane Boyer-Vine.
Hi, I'm Diane Boyer-Vine. I'm the Legislative Counsel for the state of California.
Professor David Carrillo.
Morning, everybody. David Carrillo, Executive Director of the California Constitution Center at Berkeley Law.
Anna Cubas.
Good morning. This is Anna Cubas, College Professor here in Los Angeles.
Jane McAllister.
Good morning. This is Jane McAllister. I am an attorney practicing in Modesto, California.
Richard Rubin.
Good morning, everyone. Richard Rubin, retired attorney, talking to you from very smoke-filled Marin County.
Richard Simpson.
Rick Simpson, retired longtime staffer in the state legislature and also a member of the Commission on Judicial Performance.
We'll be joined later by Commissioner Crystal Miller O'Brien, but for now, let's turn to staff. Brian Hebert.
I'm Brian Hebert. I am the Executive Director of the California Law Revision Commission.
Barbara Gaal.
Barbara Gaal, and I'm the Chief Deputy Director of the Law Revision Commission.
Sorry for mispronouncing you. My handwriting's terrible. Kristin Burford. Kristin?
Kristin Burford, and I'm the staff counsel for the commission. So is my audio working?
Yes.
Yes, it is. Later, we'll be having an election of officers, so I'll be handing over the gavel to the next chairperson. So those of you on the commission, you may want to keep in mind who you want to nominate for chair and vice chair. We'll be voting on 2 positions later in the agenda. Let's begin with meeting minutes of August 13. That's memorandum 2020-42 with supplement.
Yes, the excuse me, the supplement points out an error in the original draft minutes. In the minutes, we reproduced a decision the commission made about common interest developments and what a particular statute should look like. And unfortunately, in transcribing it from a memo and notes into the minutes, I omitted a paragraph. So this first supplement shows the omitted paragraph and where it would go in the minutes, and it's staff's recommendation that the minutes be approved with that correction.
Move to adopt the minutes.
Second.
Okay, any discussion? Seeing none, all those in favor, raise your hand and say aye. Aye.
Aye.
Anyone opposed? And I see no abstentions, right? Okay, very
Aye.
good. Let's turn next to administrative matters. Report of our Executive Director, Brian Hebert.
Okay, the first point to cover is mundane. Memorandum 2020-46, which had been on an earlier version of the agenda, has been pulled. We discovered late that there was a document assembly error that had some incorrect material in it, and rather than try and fix that at the last minute, there's not a great deal of urgency on that topic addressed by that memo, so we're just going to represent it in October. The second point and last point I have is a bittersweet one. Bitter because we're going to be losing Diane Boyer-Vine as a member of the commission. I think we mentioned before, she's retiring soon, and this is her last commission meeting. And, you know, it just is painful.
Object.
Painful that we have to do this over Zoom and that we don't have a chance to be in person, but that's the world right now. I'm not going to offer any remarks on her service as legislative counsel because I don't have a lot of direct experience with that. And I figured, Diane, you're probably going to be thoroughly lionized as part of your retirement from the legislature. But I can comment on her work as a member of the commission. Diane is ex officio, so She is a member of the commission as soon as she became the legislative council. But it wasn't just a formality. I believe, Diane, you came to the first commission meeting after your appointment, and
Yes.
she's been very consistent as an active participant in the commission. And so she's had a huge part to play in the work that the commission has done. I believe that you were appointed 18 years ago, approximately, as legislative council.
18 years.
And I went back and did a little digging through our annual reports, and I found a statement in an earlier one that Diane's predecessor, Brian Gregory, was the longest serving member of the commission with 25 years as a commissioner. So sorry, I was hoping it was you, but I suspect you're second. I didn't run that.
There's even a longer serving legislative council beyond Brian, who's somebody between me and Brian. So.
And so I think I'd like to recognize you, Diane, in a couple of different ways as you've affected the commission's work. One is as a commissioner, and the other is as a partner of the commission. You know, as a commissioner, I think you've had an outsized influence and importance to our process because as legislative council, you have this deep well of institutional knowledge and a sense of the legislature that I'm hoping now Richard Simpson will start to fill that void once you're gone. But in the past, you were our best source of understanding of sort of what is the temperature of the legislature, what would they be interested in, what would they not be interested in. And I understand that, you know, you've always had to balance your candor when you worked in the commission with your obligations to the legislature, and that was sometimes delicate. But you've always, I think, been an excellent resource in terms of helping to steer us away from the rocks when we sometimes didn't see them, didn't understand what we were doing in terms of how it would be taken by the legislature. And that's been really helpful. It's also been helpful that you have been the head of the state's Uniform Law Commission, because I think it's been good to have such a close point of contact with the ULC and be able to, you've been able to help us reach out to and work with ULC staff, and you've been able to apprise us of issues there where Uniform Act language is on the table, and we ought to take into account the fact of it being ULC language. And then the other side of the coin, as I said, is not your work as a member of the commission, but as a partner of the commission. And I think Victor knows this, and Jane may know it. The rest of you probably don't, but Diane helped save the commission's existence more than once. Back in we were one of the boxes that Governor Schwarzenegger wanted to blow up when he first came into office. And I think it's really easy when a new governor comes in and there's a fiscal crisis in the state to say, what are all these boards and commissions, and do we really need them? And fortunately, the legislature understands better the value of the commission's work and how it serves the state. And so we weathered the first several years of Governor Schwarzenegger's administration with the backing of the legislature. But then in his last budget, Governor Schwarzenegger had a clever idea, which was that he didn't want to defund us, but he wanted to make us funded by the legislature rather than the general fund. And so it sort of pushed it off his plate onto the legislature's plate. Fortunately for us, Diane volunteered that she had sufficient funding by foregoing other important things that her agency needed to do to be able to cover our cost out of her budget. And that was done first in 2010-11, I believe. So it's been about 10 years, and she has graciously done the same ever since. And you know, it's sort of, I think, become bureaucratized and you know, the product of inertia, it's now sort of the status quo. But it was not at first. And, you know, there was a real question about whether the commission would continue to exist before she stepped up in that way. Another thing that Diane has done for us is, you know, we have gone through many belt tightenings over the years, and we have very few notches on our belt to tighten because we're so small, and about 85% of our budget is personnel costs. We have very little operating expense. And because we're so small, we have to contract out for certain kinds of work. Like we're previously having DGS do our accounting work, our fiscal work. And part of the reason for that is because we're so small that we don't have enough people to achieve the statutory minimum separation of functions that's required for accounting work. We just don't have enough boxes in our org chart. And so we worked with Diane, and again, she very graciously helped us with that. So for, I'm not sure how many years, this probably preceded the Schwarzenegger thing. Diane's staff has been doing our accounting work for us, our fiscal work, at cost, which is significantly lower than what Department of General Services charged us. And I would say the work is significantly better than what we received before. So that's another way we managed to, at a time when we had to achieve cost savings and we had very few options, that was a way that we managed to do that with her help. And then, you know, it's also just been great, Diane, to have you as a sympathetic ear to sort of bounce ideas off of. We are a tiny entity. We don't have a lot of entanglements with other bodies and state government. And there are times when we run into problems for the first time, and it's just been really helpful to be able to talk to Diane about it and get her sense, because she's so much more plugged into larger processes in state government. You know, like how would we approach Department of Finance about this? You know, how would we talk to the legislative leadership about this, that kind of thing. And so the help that has been extended to the commission has been critical and significant. And so, like I said, bittersweet. We will really miss you, Diane, but it's been a great pleasure and honor to know you and to work with you for the last 18 years. Congratulations on your retirement.
Thank you, Brian.
We'll have to tell Crystal that she missed it and she can watch it on YouTube. Richard?
So, just a quick thing. I retired October 1 also about 4 years ago, and Diane and I were colleagues and friends for what, 25 years, give or take. I think she and I first connected when she was in the education unit in legislative. Right. And so we've seen many laws and constitutional amendments and all that sort of stuff. And she's helped me work through so many complicated pieces of law and constitution that I can't even recall. But it was nice to be able to join this commission a year ago to sort of have a chance to reconnect. So I will miss you, as you know, as we've already interacted. But wish you well. Wish you well.
Thank you, Rick.
Anyone else?
Thank you all.
Jane's got her hand up, but you're muted, Jane.
Sorry, I'll unmute. Diane, I just wanted to thank you so much for your leadership in helping us in the commission. When I first came, I have had no governmental interaction whatsoever. I was in private practice, I still am in private practice in Modesto. And I just remember that first meeting, how helpful and positive you were, and the way that you were able to help those of us who had not had those experiences move through getting our feet under us in this commission. So you're one of the sharpest people I know. I am really always been very impressed with you and thankful for your input.
Well, I want to thank everybody, if I could, Victor. I've served with a lot of commissioners. I started on this commission with kind of the star of real property, Ed Regalia, and David Hebert, who I went on to be Obama's first openly gay ambassador to New Zealand. Really interesting folks. And it's continued all the way through the current group. And I really like the fact the commission's expanded beyond lawyers. I think it brings a great perspective. Some of you I've served just for a while and appreciate all we've gone through in some of these areas. I really want to thank the staff. I think the Law Revision staff is probably the best. I love my staff, but they are, bar none, some of the best drafting attorneys I've met, and they provide us with so much guidance and a kind of road signs as we go through these meetings to help us along. And that started with Nat Sterling, who was the executive director, longtime director when I started on the commission, and continues with Brian and Barbara and Kristin and everyone else. So thank you all very much. I'll miss everybody, but I have other things I'm doing with the Uniform Law Commission still in retirement, so I'm excited about that. Back to education law, Rick, with the School to Prison Pipeline Project. And so I'm looking forward to kind of doing all of that without everything else going on around me in my world. So thank everybody. And now we need to get back to work, Victor.
Okay, well, thank you, Diane. The state and the commission are in your debt. Crystal Miller O'Brien and I have worked with you the longest of the current commissioners, and we've appreciated your guidance and we'll sorely miss you. So congratulations. Normally I'd be handing you your plaque for service, I believe. So I'll do that virtually, and I guess you'll get it in the mail. Anyone else? Okay, Brian, does that complete your executive director report?
It does.
Okay, moving on then to commissioner suggestions. This is the part of our meeting where we have an oral discussion where commissioners may propose new study topics and discuss procedures or other general matters. Unfortunately, on my Macintosh, I can't see all the commissioners, so I'm going to rely on you, Brian. I only see 4 at a time. Do we have any takers beyond the 4 that I see, or at all? None?
I see none. Victor,
Okay.
you might try looking in the upper right-hand corner of the Zoom window to see whether you're in speaker view.
Ah, thank you. Thank
or
you.
gallery
Okay,
view.
great. Now, good. I was getting quite lost there. Very good. Thank you for pointing out that feature.
Sure.
If there are no objections, I'd like to skip the election of officers because we are missing a commissioner, our vice chair. So we'll come back to that later in the agenda. So skipping the election of officers, let's move to the 2020 legislative program, memorandum 2020-43.
Right. This is information only, no decisions. With respect to the commission recommended legislation, there's been no change in their trajectory. All of the continuing bills are on track. They're all approved by both houses on their way to the governor. I say continuing bills because, as I've noted before, the 2 bills that would effectuate the commission's recommendation on the Public Record Act recodification were pulled by Assemblymember Chow for COVID-related reasons, and hopefully we'll have those back next year if things are better in the world, or some future year if they aren't. Good news for our other proposals. They continue on track towards enactment. The only significant new piece of information is that, I at the last meeting, I mentioned that I'd been contacted about the fact that a particular bill on electronic wills, AB 1667, was going to be amended to convert it into a commission study bill. And that amendment was made, and in that form, the Senate Committee on Judiciary approved it. But then it stalled in Senate Appropriations and never got out of that committee. So unless it's revived in an extraordinary session, which is something I know almost nothing about because our bills usually don't wind up in extraordinary session, unless that happens, it's dead. It could come back in the future, but Diane, am I correct about that?
Well, you always have to see what the call of the special session is. Highly unlikely that electronic wills would make a call of a special session, I think. Unless they decide there were some things that didn't get done at the end of session that they broadly make a call. You agree,
Yeah.
Rick?
Agree. Yeah, I agree.
I assumed that it would be reserved for sort of COVID emergency stuff, and this is not that. But we might see it come back next year because I don't know why it died. And it may have just been a sort of resource crunch at the end. We'll have to wait and see. But for now, it's not enacted, and so we won't be working on that topic next year. And we'll discuss sort of the commission's workload and priorities at the October meeting, but I just wanted to let you know that potential study seems to be gone. That's all I have on legislative program.
Okay, next we're going to turn to more substantive matters, our eminent domain pre-condemnation activities, Memorandum 2020-44. And again, we will invite audience participation at some point, so you may want to raise your hand if you want to be heard on this topic. Is that yours, Brian?
Yes, it is. And I'm looking at the list of attendees, and I don't see anyone who I think would be here on this, but if I'm wrong, we can sort of call for hands later. Yeah, this is Memo 2020-44. This is on eminent domain, which is the law that governs taking of property for public use and the compensation of the property owner. The law on eminent domain in California was drafted by the Law Revision Commission. So we keep our eye on it. And if we see that the problems have developed, then we have an interest in going back to it and fixing it. And in this instance, there was a California Supreme Court decision couple 3 years back, Property Reserve Inc. versus Superior Court, where the court assessed the constitutional adequacy of part of the eminent domain law. The part of the law that was at issue is an article on what's called pre-condemnation activity. So condemnation is the court proceeding that's used by a public entity, or a condemnor, I should say, to take property for public use. It's a formal court process. But before you commence a condemnation, the potential condemnor can also petition the court for permission to enter property that it's considering condemning in order to do testing and surveys to evaluate its suitability. So, you're going to do a big public works project, you're not sure which way you want it to go, so you're going to do like geological surveys and core sampling or whatever you need to do in order to figure out, is this particular piece of land going to work for this project? When you do that, you get when you go through that process, you get the court's authorization to enter the property, and you also have to put a deposit down with the court in the amount of the probable compensation that would be owed to the property owner for your interference or in their use of the property or your damage of the property. Those are compensable under the statute. So the California Supreme Court was looking at that and thinking about whether or not that process is sufficient to satisfy the requirements of what's called the takings clause of the Constitution, either the US Constitution or the California Constitution. They both have takings clauses. And it concluded that the statute was mostly constitutional. It found one shortcoming, which is that there's nothing in the statute that says that the property owner has the right to a jury trial to determine the amount of compensation that they're due. That's a constitutional requirement under California's Constitution. So rather than invalidate the statute over that infirmity, the Supreme Court reformed the statute, which means that, they gave it an understood meaning that's not actually in the text of the statute. And their reformation of the statute was to include a right of a jury trial on the issue of compensation owed, the amount of compensation owed. So the commission, a couple, 3 years ago, we talked about that case. And the fact that the result of that case was to save the statute, but to do it in a way that made the meaning of the statute, the legal meaning of the statute, different from the text of the statute, which we were concerned might just be a source of confusion and error, where you can't just read the black letter of the statute and understand what it means. You have to read it in connection with a case in order to understand it. So the commission decided that it wanted to look at the possibility of codifying the court's decision in that case, just to add into the text of the statute the right of the property owner, a waivable right to a jury trial on the issue of the amount of compensation owed. So that piece of it was pretty straightforward. We kind of got sidetracked because we got input from other entities about other things that we might do related to pre-condemnation activity. Some of that the commission decided to drop after considerable study, but there were also a couple of pieces that the commission decided to include in its tentative recommendation. Things like making express in the statute the right of the property owner to seek compensation for pre-condemnation harms in the subsequent condemnation action. So rather than having to take the compensation out of the deposit with the court under this special procedure, if you know the condemnor is going to be taking your property, you might think it's easier and more efficient to just wait until they actually start a condemnation and then include your claim for pre-condemnation harm as part of that. And so the tentative recommendation would make clear that that's permissible. And then we also did a couple of other things that had to do with pleadings and similar treatment of what's called clopping damages from the case name that first established recognized this kind of compensation, clopping damages. So the memorandum well, back in, I think it was in June. Yeah, in June, we circulated a tentative recommendation that pulled together all of the little pieces that I've just described. And they're described in the memo before you today. And we put it out for public comment. The public comment deadline was August 8th. We received no public comment. This is not really that surprising because we had lots of public comment earlier in our process when we were working through these issues. And so, for example, the parties in property reserve were both represented in our process as we worked towards the development of the tentative recommendation. So I wasn't too surprised that we didn't get any comment. But as a result, what I'm proposing here is that we proceed with the tentative recommendation and convert it into a final recommendation. There is a draft of a final recommendation attached to the memorandum. And it's my recommendation that the commission approve it as a final recommendation, and then we would post it to our website and move forward with seeking an author for implementing legislation. Does anyone have any questions about that? I see Commissioner Miller O'Brien is here. Welcome. So let the record reflect that. Does anyone have anything they want to say about the draft of the final recommendation that's attached to the memo?
Does anyone want to make a motion to make this a final recommendation?
Yep. Rick, I will move that we adopt the final recommendation as proposed in the memo.
Second.
Okay, I see. Any discussion? I see no audience people raising their hands. So let's take a vote. All those in favor, raise your hand and say aye. Aye.
Aye.
Anyone opposed? See none. Any abstentions? I see none.
I saw Crystal raise her hand. So
oh, I'm sorry.
I'm abstaining.
Oh, I'm sorry. I didn't see you there. Okay. Very good. Let's go backwards a bit and revisit an item we skipped earlier, the election of officers. Customarily, every fall, we elect a new chairperson and a new vice chairperson. So let me open the floor to nominations for the next chairperson of the California Law Revision Commission. If I don't see any, I'll go ahead and, Jane, go ahead.
Sorry, I had to unmute. I was going to nominate Commissioner Miller O'Brien for chair and then Commissioner Simpson for vice chair.
Second.
Okay. Any further nominations? I see none. Okay, any discussion? I see none. All those in favor of Miller O'Brien being chair and Mr. Simpson as vice chair, raise your hand and say aye.
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 You guys,
Any opposition? I don't think so. Any abstentions? What's so funny, Commissioner O'Brien?
Yeah.
Or President O'Brien? The motion carries.
I don't know what Crystal's vote was on the motion.
I'm abstaining.
Okay.
Okay.
It's mean. All right, that's fine.
Okay, that seems to be unanimous. So thank you for the pleasure and the honor of being your chairperson. At this point in the meeting, if you're ready for it, Crystal, why don't we continue with item 5, statutes made obsolete by trial court restructuring. I hand the gavel over to you. Thank you.
I want to thank Victor. We'll hook him up with a plaque next time, but thank you. If you guys could just clap, that would be nice. Unmute yourself if you can. Thank you, Victor. You did a fine job, and I worked with you for so long, and I appreciate you leading us.
And I wanted to add that, you know, my appreciation too, I always appreciate the service of commissioners as chair and agree that Victor did a great job. But during this last year, things have been so topsy-turvy. It's been really great to have a steady hand on the tiller. And you helped guide us through these problems. And I think we found our way through them, but I think that's in part because of your leadership, Victor. Thank you.
And of course, my leadership totally depends on staff. So I want to thank you, Brian, and Kristin Burford, as well as Steve, who's now gone over to the Keno side of the commission. So thank you for this honor, and take it away, Crystal.
So Crystal, the next item up is, I believe it's trial court restructuring.
Okay, let's go to that.
Number 5 on the agenda.
Thank you. Number 5 on the agenda. Just pulling that stuff up.
That is my memo. It's memorandum 2020-45. In July, the commission released a tentative recommendation on the 3 regional justice facilities acts, proposing to repeal those acts. There were no comments on the tentative recommendation. That is not surprising because we previously circulated a discussion draft on the topic and got comments then and took those comments into account when preparing the tentative recommendation. Attached to memorandum 2020-45 is a draft of a recommendation. It's essentially the same as the tentative recommendation with just a few typographical corrections, some updating of citations, and routine changes to convert a document from a tentative recommendation into a final recommendation. And so the question for the commission today is just whether to approve the draft attached to the memorandum as a final recommendation for submission to the legislature. I guess we should check at this point whether there's anybody who has any comments on the matter from the audience, and then whether there's any discussion among the commission.
I'm seeing nothing from the audience.
Yeah, we have a good, well, it looks like we have what, 9 attendees? Does anyone have any comments to add? All right, seeing none made. Does anyone want to make a motion on approving?
Motion.
Okay, so we have a first and we have a second, and the record will reflect that Commissioner Rubin and Commissioner Rubin made the motion and Commissioner Simpson approved it or seconded. Let's go ahead and take a vote or a roll call. All those in favor of approving the recommendation?
Aye.
Okay, it's a consensus. Okay, so it's a consensus. So so the staff's recommendation is adopted.
Thank you.
Thank you.
We are moving fast. So which we're now, or do we take the items in? I joined the meeting late. I do apologize. So we're on number 6 already?
Yeah, I think the bulk of the time at this meeting will probably be spent on discussing common interest developments. That's what the audience is here for. I appreciate their patience, and I think it makes sense for us to continue to move through the preceding items in agenda order, just so that we can get them out of the way and not have to sort of artificially end the discussion of CIDs in order to get back to things.
Okay.
So yeah, number 6 is next.
Well,
Okay.
number
6 on the electronic agenda. We dropped memorandum 2020-46. So that's off. We're now moving to memorandum 2020-36 on state and local access to information from communication service providers. Is that all right, Crystal?
Yeah, no, absolutely. Barbara, are you ready to go?
No, that one's mine, actually.
All right, Brian, you then.
That's all right.
2020-36, okay.
So the broad backstory, and you've seen this memo now twice, basically. It was on the agenda, an earlier version was on the agenda for the last meeting, and we didn't have time to consider it. So it's been slightly revamped and represented here. And this is part of the Commission's study of essentially government surveillance of electronic communications. And we did a lot of work. We were tasked with evaluating the statutory and constitutional requirements for electronic surveillance, as well as making recommendations for improvements of that law if we discovered any problems with it. And we did that work. We concentrated first on the background legal and statutory and constitutional analysis. And then just as we were getting to the point of identifying defects in existing law in California, there was a bill introduced that basically preempted the field of most everything that we were considering addressing in our study. So at that time, rather than sort of step on that bill as it was pending in the legislature, the Commission decided to postpone further work on that aspect of the study and instead prepare a background report on our conclusions about the legal requirements for this kind of surveillance. And we did that, and it was a final report. And then the legislature enacted the bill that had been introduced. And so the Commission decided, as it often does, that it would be best to let the dust settle on that major change of California law, anticipating that there would be follow-up bills and that practice under the new law would provide useful information. And so we decided to postpone further work on it for a few years. And just this year, we have reactivated that work. And we are working our way through each of the potential problems that the Commission identified early on to see whether or not we want to proceed with a study and then a recommendation for reform. So that's the broad brush background on this. This memo presents one of those issues, another in a series of issues. And it has to do with the meaning of the word interception, as that term is used in the US federal and California wiretap statutes. Early on, the Commission identified a series of federal court decisions that construed the term interception quite narrowly, in a way that seemed like it might be problematic. I don't want to reiterate the whole substance of the memo because I think the ultimate resolution of this memo is going to be fairly straightforward, but the core problem is a technical and practical one. The reason why it matters whether or not the Wiretap Act applies to a particular interception of a communication is because the Wiretap Act has special requirements in it, what are colloquially known as super warrant requirements, that were developed legislatively to address a US Supreme Court decision, Berger versus New York, that identified some special Fourth Amendment concerns that exist when you are either wiretapping or using a listening device to intercept communications. And this was decades ago. It was pre-internet. And pretty much at that time, if you were going to intercept someone's communications, you were doing it contemporaneously. You were intercepting them almost always at the time the communications were occurring. And so there really wasn't an issue with sort of the timing of when a court authorized you to do it and then when you actually wound up doing it. There is now an issue that we've seen that's been discussed in the prior materials having to do with computers, because computer communication is different from an old school copper wire landline, because it uses computer systems that break the communication up into pieces and send them off over various channels and reassemble them. And there are waypoints along the way between the source and the destination, and communications may be copied or accessed at any of those various points along the way. And so it's just, as a practical matter, it's quite different from putting a bug in someone's office and then listening to it like it used to be. And the reason that this matters is because the federal court decisions have held that interception for the purposes of the wiretap statute means access contemporaneous with transmission. So it has to be that you are acquiring the information at the time that it is being sent. And that made clear sense when you were talking about tapping someone's phone lines. It doesn't make as much sense when you're talking about intercepting someone's emails. And there have been cases with fact patterns, just to illustrate how this plays out in the real world. Somebody set up a script on their boss's computer so that every email sent by or to their boss got forwarded to their email account. They did it surreptitiously without permission. And so they were effectively getting copies of all their boss's email. But there was an interval of delay between when the message was sent and when it was forwarded. So then you get this line drawing problem about whether or not the federal definition of interception has been satisfied, whether it is acquisition contemporaneous with transmission, because there is this interval of delay. And you could set that interval to be whatever you wanted it to be. It could be, a second, or it could be a day. And the courts have come down differently on different fact situations about how much delay is enough to prevent it from being an interception. And instead, it kicks it over into another statute that governs access to stored communications. The reason it matters for our purposes is because the statute that governs access to stored communications uses just a regular old warrant. It doesn't include the super warrant that was designed to address the Fourth Amendment concerns identified in Berger versus New York. And so the question was presented in the earlier materials and in this memo about whether or not that's a problem, whether or not law enforcement could use a regular warrant to do what is effectively an interception, but not legally an interception under these federal cases. And that, I think, is a problem. I think it's a logical problem. I think it's a conceptual problem. But what I came to sort of conclude in this latest memo is I'm not sure that it's a real world problem for a couple of reasons. One is I don't have any evidence that any law enforcement is actually doing this. They're actually going into a court and saying, I want a garden variety search warrant that authorizes me to tap somebody's email for some period of time. I suspect that a judge who received a petition to do that would reject it and say, no, that's a wiretap. And it's conceivable that they might wind up wrangling, and the DA might make the arguments that I've identified in the memo and say, no, it's not governed by the Wiretap Act. But I think in practice, it's likely that law enforcement's not doing that, and courts wouldn't stand for it, even though there is a legal argument to be made. More importantly, I think there's this issue about whether you give contemporaneous notice to the target of the search. Under a garden variety search warrant, you do. You notify the person, you serve it on them when you're searching them. They know they're being searched. There is an exception that exists for emergencies, but the general rule is when you use a search warrant, you give notice of the search to the target when you conduct the search. That's not true for super warrants, for wiretaps, because often the efficacy, perhaps always, the efficacy of a wiretap depends on the target not knowing that you're listening. You're wanting them to say incriminating things on the phone to their colleagues so that you can use it as evidence against them. If they know you're listening, they won't. So, it would be just nonsensical to request a wiretap by using a device that then requires notice to the target. So I think if law enforcement wants a surreptitious interception, they can only get that under the Wiretap Act. So I think that in the real world, while I think the problem that this memo discusses is theoretically sound, I think it's a conceptual defect in how this is understood. I'm not convinced that it's causing actual problems in the real world. And we do have, in the past, we have received input from ACLU of Northern California where they say, don't do anything about this. Don't do what you're proposing to do, which I won't get into unless somebody wants me to sort of walk through that. They don't
just looking at the newer commissioners, are you guys, I mean, Brian, you might just want to kind of just touch on just some of those topics because we did spend a lot of time on this in the past.
Okay. So the suggestion that was originally floated for how to address this was to replace this federal standard of what constitutes an interception, which is access contemporaneous with transmission. Replace it with a rule that turns on whether or not the surveillance is going to be done prospectively or retrospectively. So if I go into court and I say, I want to collect this guy's emails for the next 3 months, that would be an interception governed by the Wiretap Act. If I go in and I say, I want to collect this guy's emails from the last 3 months, that's access to stored communications. And there's a logic to that because I believe that the special concerns that the Supreme Court identified in Berger versus New York all turn on the prospectivity of the interception. They have to do with the fact that you're going to be doing this for some period of time into the future, and we can't be sure what you're going to catch in your net. And you're not going to give notice to the target. So those are things that are true only because the court is authorizing you to act prospectively. And therefore, the super warrant requirements are necessary to address the special Fourth Amendment concerns that arise when you do that prospectively. When you do it retroactively, I don't see that as a practical matter as being any different than any other access of stored records. You can go into the court and you can say, I want this universe of documents. And the court can say, okay, you need greater specificity, or that's a sufficient amount of specificity. There's no issues about duration. There's no issues about contemporaneous notice. So all of these special super warrant requirements don't seem to bear on looking back at electronic records. They only are relevant when you look forward to future records that don't exist yet at the time that the court authorizes you to act. So that was the proposal, was like, maybe we could recast this along those lines, and that it would be a more workable way to make sure that the super warrant requirements apply where they're needed, but not where they aren't, where they don't appear to be needed. ACLU, Northern California, doesn't like that. They wrote us before. They don't think it's necessary, and they also think it's counterproductive, because it's their view that the California statute that was enacted a few years ago, CAL-ECPA, California's Electronic Communication Privacy Act, CAL-ECPA, was intended to apply to everything. And so they did not want us to propose a new statute that would create a divide between certain different kinds of situations. They want CAL-ECPA to apply to everything. And so they see this as a move in the wrong direction, and they also see it as unnecessary. They don't think it's a problem. Now, I got an email this morning from Chris Conley, who's the person at ACLU who's been working with us. And he said, I haven't distributed it. Sorry, thanks for your patience. Okay, here we go. He says, after further discussion, the ACLU will not be submitting substantive comments on Memorandum 2020-36, nor will I be able to attend the call tomorrow. Well, I guess I got this yesterday. In brief, while I may disagree with the Commission's arguments concerning a substantive difference between prospective and non-prospective capture of electronic communications, we believe at this point that further analysis is likely premature as we evaluate the court's interpretations of the safeguards that CAL-ECPA puts in place, many in fact directed at precisely the same concerns as the Berger case and the Wiretap Act. Thank you again for your time and consideration. So again, they're not buying my analysis in terms of how the prospectivity and retroactivity map onto the concerns raised in Berger. And they would rather that CAL-ECPA sort of be left undisturbed to develop over time without this kind of what they see as sort of dissonant approach being taken in the zone covered by CAL-ECPA. So we're not going to have any audience comment on this that I can see. Chris couldn't make this meeting, and the staff's recommendation at the end of the memo was, let's just drop this. I don't think that it would be a good use of our resources to push on a problem that may be merely theoretical, where the proposal is opposed on its merits by ACLU as sort of one of the principal, I think they were the sponsor, or if not the sponsor, one of the principal supporters of CAL-ECPA when it was enacted. And so it just feels like we'd be pushing a rock up a hill, and then the legislature would push it back down and probably not thank us for it, because they would see this as work that was unnecessary or was in tension with the reforms that they recently enacted. So that's my recommendation, and I'm happy to entertain questions about it or see what people think. I see a hand from
Commissioner Rubin, yeah.
Thank you, Chris.
I'm very, very satisfied with the analysis that Brian and staff have gone through in formulating the recommendation to drop this. I think it's appropriate that we not take more time of staff in something that's already been exhausted, and for which I don't foresee there will be any potential judicial challenge of any consequence that should concern us. The issues of wiretap have actually come into play not merely locally and on a state basis, but more so on a national basis where issues of national security are involved, and we've been exposed to those problems over a considerable period of time in cases we're all familiar with. So I highly recommend that we support the proposal as Brian has put it forward.
I would move for that. And do I see anyone seconding this motion? Okay, good. We have a second. And do we want to, are we prepared to vote? There's no other comments from the audience. And so are we all nodding with we approve of putting this on the table? Okay, so then that motion passes. So we're done with that study for now, Brian. Okay.
Any abstentions? No? Okay, thank you. So there's still a couple more issues that we had identified in this broader study that we'll just proceed with them at a future memo. Thank you all.
I think it's good in the interest of time. And so we can move forward to the next study. Let's see, number 7, the recodification of toxic substance statutes.
Yes, that's me. So I'm going to start by apologizing if there's any sort of mismatch between my video and audio. We have a very high Zoom burden in my current location, so I'm using my phone for audio. Hopefully that works out and my video isn't too laggy, but we'll try this and see how it goes. This should be relatively brief. Memorandum 2020-47 just presents a status update for the Commission. The Commission in this study had completed the first portion of the recodification that it needed to do. So there were 2 chapters that it was assigned to recodify. One of those chapters, Chapter 6.8, was the one that they started with. And back in January, we completed a full tentative recommendation to recodify Chapter 6.8 and a tentative recommendation to make the associated cross-reference updates. So those were released. The comment deadline was July 24th. We've gotten comments from the Department of Toxic Substances Control and an attorney in private practice, Peter Weiner. At this point, we needed to go back to the department and seek some clarification about their comments. And we are working with them to try to get those comments prepared to present to the Commission so that we fully understand what changes they're requesting and we deal with the comments appropriately. And instead of trying to deal with comments piecemeal, we've elected to just push this back and we will be dealing with their comments in a future memo. So at this point, there's no decisions, just an update. Are there any questions from the commissioners?
No, we're zooming through the.
Seeing none. That's all I've got. Thank you,
Kristin. I want to just take a quick moment before we jump into common interest to thank Commissioner Boyer-Vine. I understand this is your last meeting with us. What a sad occasion. I miss her. She's been a staple for how long, Diane?
18 years, Crystal.
Are you sad? Are you excited? Or how do you feel right now?
Oh, both. A little bittersweet, but I'm excited to get on next steps. So, and Brian did a nice job at the beginning thanking me. So thank you.
Great. Okay, I just wanted to make sure that we took the time and then also gave you an opportunity in case you had pending issues that you needed to take care of, because I imagine our common interest discussions will probably may go a little. All right, well, with that said, then let's go ahead and jump into common interests, and that's our agenda item number 8. And I know we have an audience, so I'll just try my best to monitor the attendees. Just make sure, if you can, use the button on the bottom that allows for a chat through the participants button. I think if you click on it, then you can raise your hand. Other than that, let's go ahead and start.
Yeah, this is my topic. And there's actually 3 memos that are sort of under the same broad subject heading of emergency-related reforms in common interest developments. Memo 2020-48 presents a draft tentative recommendation of a proposal to authorize use of electronic communications in conducting teleconference meetings for CIDs. We've been talking about that. This is a draft of the proposal that we could send out for public comment. Memorandum 2020-49, and it has 2 supplements, one of which was sent out this morning, is a vehicle for collecting the written comments submitted by the public. And, you know, the reason why I did that is in part because because we actually have 2 threads going right now. We have 48, which is the teleconference meetings, and we have 50, which is discussion of electronic elections. And as expected, some of the comments sort of straddle both topics. And so it was easier just to have a separate place to put comments. And also, you know, as you have seen and will see, common interest developments is a lively topic in which a lot of people have strong interest and want to share their views with the commission. And so we often will get waves of comments. We'll get a first wave, and then we'll get a second wave that sort of comments on the comments, and etc. And rather than cluttering up the main memos that are presenting points for decision, I thought it'd be helpful to have a separate memo to sort of aggregate those waves of comments that we've gotten. Okay, so into the substance. Memo 2020-48 continues the discussion we've been having about the use of teleconferencing in common interest developments in declared emergencies. And I have prepared a draft tentative recommendation that's attached to this memo that implements the decisions that the commission made at the last meeting. And at the last meeting, the commission made good progress and made decisions on all but one of the issues that were on the table at that time. On the last issue, which has to do with the method of notice delivery, the commission talked through some of these matters, but didn't reach a final decision. Instead, they asked that the staff bring back the issue for decision at this meeting. And that is the main unresolved point in this memo, and we'll just jump right into it. If you're holding these meetings entirely by electronic communication, by teleconferencing, with no physical location, as we're proposing to authorize in emergencies, it's important that the membership of the Common Interest Development have effective notice of how that meeting is going to be conducted so that they can participate. And a couple of the things that are in the draft that were decided at the last meeting have to do with the content of the notice. But the last unresolved issue had to do with the method in which that notice is delivered. And under existing law, notice of board meetings is by what is defined in the statute as general delivery. And general delivery is essentially by methods that aren't individualized, sort of broadcast methods, one of which is physical posting. And at the last meeting, what prompted the discussion was a question of whether or not the statute should bar physical posting of these notices as the sole method of providing notice. And we had a lively discussion of that, and sort of where we were heading at the end when we reached a stopping point was there were some commissioners who were expressing interest in preserving the existing option of general notice so that you could still post notice or use other methods of general delivery, so long as the members have the option of opting into individual notice for meetings. And to make sure they knew about that option, the option could be publicized in the statutory annual notice that CID boards give to all their membership through individual delivery. And that was not the decision of the commission, but it was where we were, there was an interest in that possibility because there was concern. I mean, the essential issue is sort of like the benefit of actual individual delivery is everybody gets it. The disadvantage is cost. You know, are you going to have to, if you're having monthly meetings, are you going to have to mail these notices out to your entire membership every month? Not a trivial cost. So this solution that we were moving towards has kind of a nice balancing mechanism built into it, which is that you give the individual notice to people who actually want it, and make sure they know that they have the option so that it actually does approach giving individual notice to everybody who knowingly requests it. So the cost of individual notice is there, but it's limited to sort of the audience who is affirmatively interested. You're not going to have to mail to everybody, even those people who couldn't care less. So after that meeting, as I was digging in and preparing this memo, I realized something embarrassing, and embarrassing for me because I did the recodification of the Davis-Sterling Act years past, and I drafted these provisions originally. And I had just simply forgotten that where we wound up with these notice rules is basically what the commission was proposing at the last meeting. So existing section 4045, which is the general delivery provision, basically says what I just described, which is general delivery can be given by any of these various broadcast methods, including posting, but there is an express provision that says that any member of the association has the right to receive general notices by individual delivery methods, which can include mailed delivery or, if they've consented to it, email. And the option of opting into individual delivery is specifically something that has to be called out in the annual notice that the association gives to its members. So every year they get this formal report saying, here's a bunch of things that you should know. One of them is you have the right to receive individual notice of board meetings. All you have to do is ask. So the existing law already does what the commission was moving towards as the best compromise approach. So as it turns out, we don't really have to say anything in the statute. If that's the result that the commission wants, we can rely on existing law. The only wrinkle being that I did propose some comment language for our proposed provision to help people even more so understand that the right exists. So in the middle of page 3 of the memo, I drafted this proposed comment language that says paragraphs B1 and 2 govern the required content of notice of a meeting conducted under this section. The method of delivery of a board meeting notice is governed by section 4045, general delivery. Under section 4045B, any member has the right to receive meeting notice by individual delivery under section 4040, which can include delivery by electronic mail. That option must be noted in the Common Interest Development's annual policy statement, see section 5310A4. So that would help alert people that this is the controlling law on delivery of notices of meetings. I'll add one more background fact, which is another thing that we discussed at the last meeting that I think is important, is that the part of the purpose of these notices is to give people the link that they will use or the telephone numbers that they will use to participate in a teleconference if they want to participate in it. And it's hard for people if all you're going to do is like post the notice. It's hard for, or even just mail hard copy notice. It may be hard for people to sort of transcribe this lengthy nonsense URL that Zoom produces for the meeting and get it correct in their computer so that they can make the connection. Whereas if you get these notices electronically by email, it's very easy to embed a clickable link. In fact, I think just providing the link, most email programs will automatically convert that into a hyperlink. And then so there's no need to transcribe the URL. They just click on it and they get to join the meeting. So that's another reason why it would be helpful for people to be able to get electronic notice if they want it. And the proposal in the memo is that existing law would achieve that at a modest cost that already exists, right? We wouldn't be imposing any new costs on anyone. These are already the existing requirements. That's all I have to say about it. I do see a hand raised in the audience. I don't know whether the chair wants to go to audience comment or.
Yeah, there's two, it looks like. So I'll just take them just in the order that they appear. Steve Link.
I will connect Mr. Link. But before I do, you know, an admonition that I've made at the last meeting too, which is that a lot of people are going to have a lot to say on these topics. And so this won't be your last chance to speak. And so if possible, I think it would be helpful if you limited whatever remarks you're about to make to this specific issue. And then later when we move on to other issues, you'll have another chance to talk about those. I will now allow Mr. Link to speak.
Hello?
Okay. Yes, we hear you.
Okay, great. So I submitted a letter to Mr. Hebert after seeing your last meeting and want to echo what he just said. I'm the president of a HOA in Carlsbad, and we, I think we bend over backwards to make sure that people know that they can access our meetings, but I'm strongly opposed to requiring individual delivery. Each year we send out that notice that says you can sign up to get it by email, or you can individually opt in to get all the meeting notices by regular mail. And at any point, if any resident wants to change their option, they can contact our manager and change it. So I would just urge the commission not to recommend that we need to go and do individual delivery because it costs thousands of dollars and it really doesn't benefit our community.
And if I may, I want to clarify what I understand you to be saying. When you say we shouldn't require individual delivery, you mean we shouldn't require individual delivery to every member. In other words, preserve existing law that requires individual delivery only to those who have affirmatively requested it. Is that right?
Yes, I'm a big proponent of transparency, and since I've joined the board, I've made sure that we're very transparent and we do individual delivery for all of our other required things. I think there are 3 mailings we need to do every year that require individual delivery, but for our monthly meetings to require that for everybody is just, it doesn't make sense. It's too costly, and we give everybody and anyone the opportunity who wants to get individual delivery to get it, and anyone else who wants to get it by email. Another quick point I could make is that as far as the URLs are concerned, we use a very simple URL. It's just gotomeeting.com and then you enter a 9-digit code. The Zoom ones can be complicated, but there are services that will allow you to simplify those into like 18 characters. So another option rather than requiring individual delivery would be to simplify the URLs, and that's easily done. Thank you.
Chair, shall we go on to the next
Yeah,
person?
let's go to Tom Sir.
Okay.